Let's discuss this now further with Dr. Suhayfa Bhamjee. Dr. Bhamjee, credible witnesses don't typically disappear from proceedings without requesting to be excused, do they?
No, they shouldn't. Certainly, evening, Oliver. Certainly not ones that, as the Commission has rightly said, and it's been said repeatedly to Advocate Batoy, that this entire Commission of Inquiry is essentially from her motivation in a letter to the President.
Yeah,
so it's a bit confounding, yeah.
Yeah, let's get into the minutiae of it, because we've heard 4 weeks of testimony and the last 3.5 days of appearances before the Commission were cross-examination. Now, perhaps it's important to sketch what brought us to this point. Advocate Nkabinde Chauke had, as part of the prosecutorial team investigating and prosecuting at least what they called racketeering by the Pretoria police unit, who was headed up by then Provincial Commander Johan Boysens, had decided to prosecute them. Advocate Shamila Batohi then said, look, you overstepped in your powers because there was not enough evidence to suggest that there was a case to be answered here by the Pretoria police unit, including Johan Boysens as well. And of course, we know that this was the same fate that Jiba had suffered, as well as Andrew, as well as the previous NDPP. Very importantly here is the question on the credibility of Shamila Batohi when she conceded to the panel that she didn't actually go through the evidence that was submitted that formed the basis for the decision. But yet she wrote to the President and said, I have sufficient evidence and have duly considered my mind that the person in question, Advocate Nkabinde Chauke, is not fit to hold office. That seems to be a very profound contradiction and concession, at least, on part of Shamila Batohi. How do you read it?
Yeah, so look, I think in, if we were talking about private practice law firms, it wouldn't be unusual for a senior partner to rely on the evidence gathering, etc., of the juniors or other partners in the firm and then sign off on that. But given the gravity of this, that what was moving forward was a indictment, if you will, on Advocate Chauke's ability, etc., you'd have expected at least a little bit closer scrutiny of even the summaries, etc., that were provided to Advocate Batoy. So it's easy to speak from the outside looking in, but given the gravity of what was weighing before her in putting forward that letter and request to Parliament, you would have expected a much closer scrutiny of the documentation.
We know by the NPA Act that the NDPP is the only person within the NPA that can make prosecutorial decisions in racketeering cases. That is to say that she can defer the appearance in court to juniors or someone else in the NPA, but the strategic and prosecutorial decisions regarding the prosecution and the direction it goes in must be taken by the NDPP. Does it seem like Shamila Batohi had adequately exercised that in this instance?
True. I'm not sure quite how to answer that one, but like I said, I think this level, as you said, it's racketeering. It should have had much more closer scrutiny, a much more tighter rein on what do we have before us, and going forward with something that you can back up, that look, this is a decision we're taking and this is how we're moving forward. Because like we've been discussing for the last couple of days on various platforms, and we've been watching on the media, other experts, that the NDPP role is so crucial, it's so critical. And like we said before, all the dots are basically connecting and coming to this one particular position, which is, opening a lot of eyes and opening a lot of ears as well.
Yeah, let's talk about that email that she claims to not have seen. Just again to sketch out the facts here, a potential witness in the actions of the Cato Manor Police Unit had claimed that he had first-hand evidence of the Cato Manor Unit having executed extrajudicial killings. This particular witness fled the country, and we now know by evidence this particular witness was sent threatening messages by Johan Boysen, who Chauke had decided to prosecute in this instance. For his safety, the witness then reached out to the NDPP through the spokesperson of the NPA at the time. We now know that the spokesperson had forwarded the exact correspondence to the NDPP, Shamila Batohi, but she claims to not have seen it. Therefore, it could not have informed her decision about whether or not Johan Boysen had a case to answer. It seems like quite the profound slight to say, I just didn't check my emails.
Well, yeah, look, the number of legal principles with that. I mean, again, now you're bringing into civil law, which isn't quite my area, but there are, rules about delivery and that sort of thing, which can come into play. But if this was email was meant to be part of the bundle of documents, information, it would have come to light at some point. She would have had to have seen it. I mean, it's not difficult to check read receipts, delivery reports, etc. But that does happen. I miss an email, you miss an email. But if it's like brought to our attention, certainly in all of this that's been going up, we would have been alerted to it and have a much more reasonable response to why, or just an honest response as to why I missed the email.
Yeah. Shamila Batohi at left here, and of course this is not the end of the inquiry, but there's a number of legal considerations here. Firstly, Andrew Chauke and his legal team can make an application to the panel that the evidence of Shamila Batohi must be struck. That is to say, it will be as though she never appeared. But that would render the panel moot, given that she had carried evidence in chief, and she's the reason, the letter she wrote to the president is the reason this panel exists in the first instance. What would be the legal effect of such a request if it were to come from the legal representatives of Andrew Chauke?
Okay, so that's a banger question. But what I will say this is, so she's not the only witness in this matter. She's not the only witness or the only person giving testimony in at the commission, but she is the key one. So the key person to bring evidence. Yeah, if it's struck off, if her evidence, if an application is brought to have her evidence struck off, you're quite right in saying it's as if it never happened, and pretty much all of whatever she could have accounted for or substantiated then essentially becomes hearsay, unless, of course, you've got other witnesses who are able to corroborate and beef up otherwise. But it's very difficult when the key witness is now testimony is no longer admissible or as if it never happened to try and secure a particular case.
Yeah, well, so Dr. Suhayfa Bhamjee, we're going to have to leave it there. Thank you so much for your time. Thank you so much for your insights. I really do appreciate it. Dr. Suhayfa Bhamjee is a senior lecturer at the University of KwaZulu-Natal in the law faculty.